Okay. No thanks, Adele. Julian, you didn't have any trouble then, eh?
Hi, no, I didn't have any trouble, but
Okay.
I just had to go and find the link because it disappeared from my Teams. Normally I have it in Teams all the time. Yeah.
That's fine. Okay. While we wait for other students to arrive, I'm going to share my screen in the meantime. Okay. So what this is, guys, this is an examination or test, basically, from another organization where labor law is also being taught, and also a tertiary level institution, and also using a textbook that's prescribed for this course. And these are typically the kinds of questions that come up there, and it's always good to dive in any pool of questions that you can find. So what we're going to do this evening is to go through these questions and test our understanding. It covers, some parts of the course, and there's a further question paper which covers another part of the same course. Okay. So I think we can wait one more minute for others to come, and then we can start. We can dive right in. In the meantime, let me ask, how are preparations going? How's your studying going?
Oh, mine is so behind. I'm getting there.
Yeah, I'm also struggling. It's difficult to balance work and studying. Sure.
I still have modules that I have assignments. The module has 8 assignments and a portfolio, so it's a lot.
Okay. No, guys, time management is of the essence here, and I leave that. That is, I've done some presentations on that earlier. How one must go about this course and the suggested way of going about it. You can look at some of the earlier recordings. And also, let me remind you, if it's getting too much, you always can make use of the one-on-one session. You can send me an email with a request. There's also a link that Adele normally posts up here. But you can also, what you can do, if that's too much hassle, you can email me directly on this email address here. And then I can start to set you up on a Teams meeting. Okay? A one-on-one consult. If you feel there's some areas that you're not really getting to, or even though you've been you're still having difficulty, getting to grips with it and understanding it. Okay, you're welcome to contact me to arrange a one-on-one. Okay, so let's get to it this evening, guys. These are true or false questions for 10 marks. Quite realistically, in a UNISA paper could ask the very same or very similar questions. Okay. State whether the following statements are true or false and give a reason for your answer. Okay, so as you know, with these kinds of it's 2 marks, so you'll get 1 for correctly identifying it either as true or false, and a second, mark for giving a reason for your answer. So let us start now. The Latin term locatio conductio operis refers to the employee. True or false, guys? Okay. This is actually the Latin term locatio conductio operis refers to the employer, or not employer, to the independent contractor. Okay, there's two Latin terms that originally defined the type of work contract that you get: the locatio conductio operis and the locatio conductio operarum. Now, the locatio conductio operis refers to the independent contractor, whilst the locatio conductio operarum refers to the employee. Okay, not difficult. It's just a question of Latin terms. It's commonly used. The common law, this is the common law now. The locatio conductio operis refers to the independent contractor and broadly referring to a contract for a specific piece of work. Okay, so I want to use your services to paint my house. Okay, that is an independent contractor. Locatio conductio operis. Okay, the operarum, locatio conductio operarum, is the employment contract. These are you have your other common law duties. Okay, where you must serve your employer, you must do so diligently, honestly, in good faith, obey instructions, you know, that kind of thing, those common law duties for the normal employment contract of services. All right, any question on that? Anything that requires further explanation? You cool with that? It's in the textbook. It's you know, where they make the distinction between the common law contracts, because both contracts, or mostly the locatio conductio operarum, the employment contract, not this one here. This is the independent contractor, but the locatio conductio operarum has gone through many changes. You know, the common law contract has been overall, it has been gone through myriads of changes. Okay, so much so that you know, it has become a study on its own. You know, we come into the realm of labor law. Hence, we come into the realm of labor law because it is that contract, that specific contract with its common law duties, the locatio conductio operarum, the employment contract, it has changed so much, okay, over time and through various things and various developments in commerce, in society, in the changing government, in so many things has had an effect on it. So that now we don't study this contract, the locatio conductio operarum, simply as such. We need to understand what it is nowadays. Okay, the basic conditions of employment, all the labor laws, the Employment Equity Act, the Labor Relations Act, have all affected the locatio conductio operarum to such an extent that it has become something on its own. Right. Can you guys hear me? It's very quiet here. Aisha has joined us as well. Hi, Aisha.
Hi, I'm here. Hello,
Okay.
everybody.
Okay.
We can hear
We're
you.
going through.
Yeah.
Okay. Okay, Queen. So we're going through a past, you know, paper of another institution who teaches the same subject using the very same textbook. Okay, this is true and false. The organization test determines whether a person is an employee by considering whether they are economically dependent on the employer. Can anybody give me some background context about what this is all about, these tests? The next question speaks of a dominant impression test. The present question 1.2 makes mention of this organization test. What are all these tests about, guys? What does it have to do with anything?
The tests were developed for guidelines to distinguish between employees and independent contractors.
Correct.
And there's 5 tests.
Right. Now, this is how you guys need to understand the whole discussion, okay? All the labor textbooks, you know, even not only of this basic one that we're busy with here. I mean, I'm talking about the you know, the authorities on the subject. They all start with explaining this difference between the employee and the independent contractor, okay? And we discussed this perhaps in the beginning. Now, why, you know, is it such a big thing to make a distinction between the employee and an independent contractor? There's many reasons, but why do you, just give me one reason why. There's this distinction between the employee and the independent contractor.
Can I go?
Please go ahead, yeah, sure.
The independent contractor is contracted to perform a specific task
Right.
to produce a specific result, and an employee is appointed to render personal services in terms of the job description.
All right, okay. So that is that discussion. So the discussion goes around that. And before the LRA, you know, even when the LRA came about, because the definition of employee, is the term employee defined in any law, by the way? Yes, it is. In fact, if you look at the Labor Relations Act, Section 213, the definition section, the Labor Relations Act has got this, you know, strange arrangement where definitions of words in the Act, which is, you know, normally, if you look at legislation, modern legislation or most post-constitutional legislation will have the definitions in the, you know, in the front of the legislation, in front of the statute. You know, there will be a section called definitions in the beginning. But this, the Labor Relations Act, right in Section 213, defines certain terms, and employee is defined as well. And an employee is defined as, you know, anyone who does work for or helps anybody in their business and receives remuneration for it, except an independent contractor. So even the definition excludes expressly the, you know, the term independent contractor, because you don't fall under the LRA if you are considered an independent contractor. And since the LRA came out in 94, 95, around about there, you know, there have been attempts by employers to disguise contracts of employment, okay, to make them appear as independent contractor agreements rather than employment agreements, so as to escape the liability that would attach to them, okay, and to in some way also then deny employees all the benefits that are afforded to them. So all these tests, as you rightly said, Aisha, came out. You know, the organization test is one of them. Now, is this true or false? The organization test determines whether a person is an employee by considering whether they are economically dependent on the employer.
That's false.
It's false, yes. Why? What is the organization test about?
The organization test looks at the person is part of and parcel of the business organization of the employer.
Right. So they will look at you in the time, you know, before Section 200 capital A of the LRA. Section 200 capital A of the LRA, which created this presumption of employment. It was very difficult because, you know, there were always ways that the employers were looking at. And when it came to a dispute now, about who is an employee and who is not, who's an independent contractor, the courts could see that the employees were saying one thing, but the employers were saying another, and the onus always was on the party who made the allegation to prove it. We've been through this before. Last week when we did unfair dismissals, we started with unfair dismissals, where we said that when you take a matter as an unfair dismissal to the CCMA, you have to prove that you're an employee and you have to prove that you were unfairly dismissed. Okay, so if you fail to prove that you're an employee and rather an independent contractor, then you can't be heard. You can't get relief at the CCMA or the bargaining councils. So this is one of the tests. So the dominant impression test tells you that the court will look at to what extent, not the dominant impression test, I beg your pardon, the organization test is where the court will look at to what extent the employee is part of the other party's organization. Okay, and a good example of that, is if an employer says, well, this person isn't an employee of mine, the person is an independent contractor, but when we look at the extent of the person's, when we apply the organization test, we see that, oh, you're quite part and parcel here. You work Monday to Friday, you've got your own office, they deduct UIF, they deduct pension fund, and they deduct medical aid. So you, for all, no matter what you say, Mr. Employer, it very much appears when we apply the organization test that the person is not an employee, not an independent contractor, but rather an employee. Okay. So there were various tests, but you are right, it is false for that reason. Question 1.3, the dominant impression test considers the employment relationship as a whole rather than concentrating on only one factor. Yes, Aisha or Gillian or Queen?
That's true.
Who's that? Queen? Yes, it's true. True. So this test, as they develop different tests, the court seemed to have stuck on, the dominant impression test to look at all the factors as a whole, and then try and make, a decision of whether the person is an employee or not. That's true. And what we can also see how true that is that the dominant impression test has been incorporated into Section 200A, 200 capital A of the LRA, which simply says that, unless or despite what the parties are saying, despite what they've written, agreement they may have, an employee is presumed to be an employee. A party is presumed to be an employee if one of the following things are present. Okay, and what they list under Section 200 capital A is in fact those things that it include tests under the dominant impression test. Okay, so they will look at various factors. It involves all the previous tests, but mostly the dominant impression test. And don't forget the Basic Conditions of Employment Act, Section 86, capital A, has got a very similar provision to Section 200A of the LRA about presumption of employment. Any questions about this?
No.
Cool. 1.4. If a person is told which hours to work, they are deemed to be employees.
I'd say yes and no.
Yes. You say yes. Yes, Queen. They are deemed, in fact, that is listed under Section 200 capital A. the fact that the person, if the employer dictates where you are going to work and your hours of work, then there's this presumption, oh, the person is an employee now. Okay. Another presumption that the LRA also makes is for fixed-term employment contracts. You know, this is one of the grounds that if you employ somebody longer than 3 months, then there's a presumption that that person is an employee. So what it comes down to is not that the employer can't disprove it. All it means is, for all these things, is that the duty to prove that the person is an employee or not is no longer on the employee, him or herself. It shifts over to the employer now to prove that the person is not an employee. Before, the duty was on the employee to show that they were employees and not independent contractors. But yes, this is a presumption that's included in 200 capital A and 86 capital A of the BCEA. 1.5, an independent contractor is not protected. An independent contractor is not protected in terms of labor law.
It's false.
You said it's false. Okay. Jillian, Aisha, what do you think?
I can't find the exact information, but I think they're not protected under labor law, but they're protected under the Constitution.
You're pretty much on the right track here, Jillian. It's true. They are not protected under labor law. In other words, the definition of the LRA tells you what an employee is, right? And the definition expressly excludes independent contractors. Okay. So if you look at section 2 and 3 of the LRA, it tells you who an employee is, but it expressly says it doesn't include independent contractor. But the counter question now is, okay, that would sound manifestly unfair under our law, and you are heading towards the right route there, that because you're not an employee, does it mean you don't get any kind of protection whatsoever? Of course not. You would have to do, what would the employees have done before the LR came out? What would properly, you know, as we understood, employees have to do before the LRA came about?
I think it's the common law.
Right. So think of it. If you are a true independent contractor and you're doing work for somebody, you can't take them to the CCMA or a bargaining council because they don't have jurisdiction to you. You're not an employee. But definitely, you have all contractual rights under the common law. And the common law, as we know, is developed quite immensely. So it's under the laws of contract, whatever that may be, you know, and however that has been influenced, you know, under modern common law, under modern contract law, it's been altered so much, you know, the common law. We've got things like the National Credit Act, if it relates to that, the Consumer Protection Act, if the party is qualified to be under that. There is various laws, but to correctly say it is actually, you know, the common law as developed. And what you said, Jillian, at the end of the day, the Constitution would protect such a person. And that is important that you mention that, because there's a case that comes to my mind now. I don't know if I mentioned it to you before. Is there a constitutional case, Jillian, that you can think of where this point was tested? Employee was not the employee as defined, and therefore this was just the point, you know, the person was excluded. Remember Kylie versus the CCMA? Kylie? The Kylie case?
I came across it, yes, sorry.
Yes, that is the case, exactly your point, where this woman was a prostitute and was, you know, not paid apparently, and she obviously couldn't take the matter further for two reasons. One, you know, she wasn't an employee as such, and two, any such contract goes against public morals. It's considered, against public policy also. So she couldn't get protection under labor law. Now, labor laws mean all these labor laws, the common ones of which you should know now: the BCEA, the LRA, the EEA, the the UIA, the Skills Development Act. All these laws, Employment Services Act, all these laws. So they won't get protection under those laws, but under the Constitution, Section 23, subsection 1 says that everyone has the right to fair labor practices. So this person, Kylie, took it to the Constitutional Court, who then said that we're not going to look at what she did, but the way she was treated, rather. And she can't get protection under the LRA or any labor law, but she still has the right to fair labor practices. And it won't fall under labor laws, but it can fall under the constitutional right that she's got. And they ordered for the person to pay a compensation, not as a result of anything under the LRA, but in terms of Section 23, subsection 1 of the Constitution. Okay, we ready to move on, guys? Question 2.1. Tanya has been working for Studio X, owned by Donna, for 7 years. Tanya is employed as a makeup artist. One day, while doing a makeover on a client named Cindy, Tanya accidentally uses too much acid to do Cindy's chemical peel. And as a result, Cindy suffers second-degree burns on her face. Cindy is furious and wants to sue Tanya for damages. Okay, just digest that for a second and now consider the questions. Using your own words, contrast the common law duty. Look what's being asked here. Contrast the common law duty of the employer to provide the employee with work and the duty of the employee to render services to the employer. Note, marks will be awarded for your ability to show how these duties differ and correspond or by using simple language. Okay. I don't think I've seen such a narrative in a UNISA question paper, but now I can see where they're getting at with this question. They want you to know what the common law duties of contract are. Okay, there's certain common law duties under the locatio contractio operarum, the employment of services. Now, what is the common law duty of the employer to provide the employee with work? What does this mean? Let's look at that, because you must compare that one duty of the employer, right, to provide work, and the other duty of the employee to render services. How would you compare this? Yes. Okay, Aisha, you wanted to say something.
I think firstly it must be where there's a contract of employment, an employer and employee relationship.
Yes. So we are talking about that now. Yeah? You must contrast these two duties. We should know what the duties are, but they're not asking you to contrast all of them. They're asking you to contrast only one particular duty in this case of the employer, which is the employer must provide work. And now let us quickly look at it. What does that mean, really? Anybody? Because, you know, as employer, the common duty to provide work means that the employer must basically, has got a duty to provide the work. So once they take you on into service, once the employee is now, you've agreed that they'll take you on, they must provide the work. If they do not do this, if an employer doesn't provide the work, does this now mean that the employee will not be compensated and be paid for that? Whose duty is it to provide work? It's the employer's duty. So how far does that duty extend? It extends comprehensively, because if there's nothing to be done, then you cannot then at the end of the month, when it's time to pay the employee, say, well, I can't pay you for this week that you worked. You know, you worked for 4 weeks this month, but for week number 2, you know, I wasn't available and I didn't give you work, so therefore work wasn't there for you, so therefore I can't pay you. Would the employer be correct in taking that view?
No.
No. So that is what it
No.
means by the way. So this is the employer's duty, that they must provide work. Failure to provide the work does not absolve the employer from having to pay the employee. Okay. It is a different question now. So contrast that with the employee's duty of to render services, right? The employer has to render services. Obviously, if they come there and there's nothing to do, that's fine. That's the employer's difficulty. But once the work is there, the employee needs to do the work. Right? Failure to do the work could lead to disciplinary action. So this is the contrast I believe they want to see with under these particular duties. Any further questions? Yes.
I just want to know why the question itself says that what you just explained now. So I don't know. For me, it's just a bit.
What is unclear there?
No, I'm saying that saying that the duty of the employer is to provide the employee with work, and that's exactly what you explained. And then the duty of the employee is to render the service. So what?
But the thing is, man, can you render services when there is no work provided?
Okay, so you need to go into that detail.
No.
Okay. Okay.
That's what they want to
Fine.
see. They want to see how far do you understand that duty to go, because technically speaking, you know, if you don't do the work, if you don't come to work, people make all kinds of implications and imply various things and deduce various things. But if you don't come to work, then the employer under common law was not compelled or obliged to pay you for the times that you don't work. You understand? Under common law. But if the employer, you know, has given you work and you do not do it, that is where the difficulty comes up. You're obliged to do the work. Yeah. But if the employer doesn't make the work available, all they need to do is they need to take you into service. So this means I'm contracted now. You've basically bought my time. And I need to work for you now from these periods to that period, working hours, working conditions, etc., etc. And now if you fail to work, you know, after the employee's taken you into service and provided you with work, then you are now on the breach end of that situation.
Okay.
Right. Advise Cindy. That'll be next question for 8 marks. This question I've even seen UNISA papers before. Okay. Although, like I said, this is not from UNISA. This is from another organization that uses the same textbook. Okay. And it could very well be repeated. It's all to show your understanding, or to test your understanding of the material. Advise Cindy whether she is likely to be successful with her claim against Tanya. Okay, Tanya's the one that burnt her or did something. What did she do? You used too much acid. Okay, so she suffered burns on her face. Ooh. Okay, with a reference to the required that need to be established. So what are we talking here? What's coming to your mind now in the first time you read this? What did you think? So for 8 marks, now you need to unpack this very nicely because it's quite multifaceted. Okay, there's a couple of issues you need to raise, and it's wise that you raise it in a particular order. You can order your thoughts and you can write it better in the test, in the exam. Yes?
I think it's the delict, what, I don't.
Yes, delict. Yes. Delict. Okay.
So, what's her name now? Cindy is allowed to hold the Studio X liable because
But
of
look at the question now. Look at the question. Cindy's the one that got hurt. She's the customer, right? So she wants to sue. Who does she want to sue now?
Tanya.
Tanya. Tanya is merely the
employee,
right? So look very carefully, guys.
Okay.
When you do test questions, examiners are very, always judge your answer by, asking yourself, have I answered the exact particular question? Advise Cindy whether she is likely to be successful with a claim against Tanya.
No.
So one could start with no or yes here,
No, not Tanya.
Depending, you could start with a yes answer or no answer and then explain yourself. So with a reference to the requirements that need to be established. So now, Tanya is merely the worker. Are you saying that the worker can't be held responsible for doing this? She, after all, appeared to have been negligent here.
Well, according to this law,
what law is that?
That unlawful or delict acts, the doctrine was no.
Yes. We're dealing with a delict now, yes, but there's a particular doctrine.
Yes. Yes. I'm just looking for it.
Yes, Jillian, what is it called? Perhaps Jillian can recall. Or Queen. Because this comes up a lot, guys. This question comes up either in assignments or tests or exams.
I know vicarious liability, but you said like that.
Vicarious liability.
Yeah, that one.
Okay. Now, let me see. Okay, let me give you this vicarious liability. What is vicarious liability?
It is the employee's wrongful conduct.
Yeah. See, the thing is, vicarious liability, you see, under the law of delict, right, which is, who can recall what a delict is again? A delict is a civil wrong, right? Compared to, as opposed to a crime, which is like a criminal or public wrong, so to speak. You do something, you break a rule, which is so serious that the state intervenes and takes over and holds you liable and in the event punishes you. Okay, a civil wrong is a rule of private law that's been broken, which you can be held liable for, but it's between individuals, not between the state necessarily. Okay, although the state can also be sued civilly. Okay, so, but in terms of the law of delict, right? I mean, which is commonly the cause of action for delict is negligence. You're driving a motor vehicle down the road and you cause an accident because you didn't apply the brakes properly or you weren't looking, then you cause damages to someone's vehicle, then that is an example of a delict, a very common delict. Okay, there's certain elements that must be proved that you did something which is wrongful and it was your fault and you caused it, and ultimately there were damages that were suffered by the other side. Okay, So one of the requirements is that you must have caused the accident. But now that is the general rule, right? Causation means now that you must be the cause of the direct cause of the accident. Who directly caused this accident against this lady here? What's her name? Cindy. Who caused her damages? Who caused her this difficulty now?
It was Tanya.
It was Tanya, right? Exactly. So now Tanya, strictly speaking, if we apply the law of dealing, like causation, then it's Tanya's fault, and Tanya should be the one responsible, right? And the question they asked us was, advise Cindy whether she's likely to be successful against Tanya. So there's a great chance that you would be able to be successful against Tanya, because if she can prove all the elements of a dealing, you know, and that is one thing you can unpack that as an answer. However, now you mentioned this question of vicarious liability, Aisha. Now, what is vicarious liability? We've now explained the general laws of dealing, right? Causation is the act, the wrongfulness, the fault, the causation, the damages caused. And therefore, on that basis, Tanya should be held liable for that. Okay. But now you mentioned this thing called vicarious liability. How is that different now? What is that all about?
It is where the employer needs to compensate the person that suffered the injury.
Well, that is, you know, when you use it, you write in a very sort of indirect way, okay? And that response, you must now try and sharpen it a bit, okay? Vicarious liability is the idea that the employer is going to be responsible for a dealing that was committed by its employee. That's vicarious liability. When you are being held liable for something, you perhaps not the direct cause of, but because of a relationship that you have with the party that caused it, you're going to be liable. Right? Your children, you go visit people, and your child, the young child, 12 years old, goes and smashes something. You know, we break something, he causes damage. Who can they sue now? Okay, it's not a criminal matter, but it was an accident, but nonetheless, damages were suffered. Who are they going to hold responsible for those damages? The 12-year-old?
No, the parents.
The parents. That's another example of what we call a vicarious relationship, right? A vicarious liability relationship. You hold the parents responsible. So in a very similar vein, and there's various under common law kinds of vicarious, or what we call strict liability relationships. Vicarious liability being one of them. And there are certain requirements that have to be met before you can actually rely on vicarious liability. What was the question, Aisha? Our question was to advise Cindy whether she will be successful against Tanya. Right? So we've explained that part. We said, yeah, you know, if we apply the general principles of dealing, then she's the one responsible. However, because now the requirements come out. So how can we now, vicarious liability, who is the employer here?
Studio X is the employer.
Right, so Studio X
I don't know.
employs Tanya. So we got it's a great likelihood that we will be successful against Tanya. However, it would be feasible and perhaps make, you know, financial sense to hold the employer liable for this, because there's three things that must be proved because of the vicarious relationship. And vicarious liability in such a scenario can only come about when there are, I think, three things that need to be proved. What are those three things? What would Sydney have to prove in order to hold Studio X liable? Okay, so what Sydney would have to, yes, go ahead.
There must be a contract of employment between the employer and employee.
Yes, good. So the first thing that Sydney would have to prove is that Tanya was employed by Studio X. All right. You don't want to hear, because now employers are aware of that. So that is why they put up independent contract agreements with people. They don't want this relationship to come about either. Why must I be responsible for something my employee does? I must be responsible. So you'd have to prove now. Cindy will have to prove that Studio X is the employer and that Cindy is the
employee.
1. 2.
The employee must have acted in the course and scope of the employment.
Well, you're jumping. That's actually the third requirement.
Oh,
What do you think the second requirement?
The employee must have committed a delict.
Right.
Negligent.
Break it down. That's good.
That
so the
is
employee must have
negligent.
committed a delict. Yes. Okay. So did what's this called? Tanya committed delict?
Yes, she did.
Yes. What is the delict?
Something that's negligent or intention, unlawful action or omission causing a third party to suffer damages or personal injury.
Right. So right, I gave you an example of negligence, and this is also negligence. Okay, and we will compare negligence. The counter of negligence is intention. So negligence is we don't intentionally cause something, but your behavior is compared to that of a reasonable person. We apply what we call the reasonable person test. And if you fail that test, where you should have foreseen and have taken steps to prevent the forbidden result, then you are deemed to be negligent. Okay, so you don't expect. Can you expect a person like what's her name? What's this person's name? Tanya to make such a mistake? She uses too much acid on Cindy's chemical peel. What is that chemical peel? Is it like a hair? What is that, like a face mask or something?
Sounds like a facial type of thing.
Okay. So, all right. So she did that and you don't expect that. Okay. Or more importantly, you don't expect the employer, the company, the person that you're doing business with to have such kind of employees who are inexperienced or don't have that, because the company is putting itself out as a business. So, one, she must prove that Cindy was employed, or Tanya was employed by Studio X, that Tanya committed a delict, and thirdly, as you said, that the delict was committed in the course and scope of her employment. Okay. Also, a big discussion. Many people try to escape this now. That was it while she was like doing something wasn't supposed to do. Course and scope means basically while she was on the job, while she was doing work for Studio X, that she did this, committed this deal. Okay, so Tanya of Cindy can hold Tanya personally liable, and she will probably be successful with that. But because there's this vicarious relationship between Tanya and Studio X, and if Cindy can prove that those three things, then Studio X could be held responsible, for this claim, for the damages that she suffered. Okay. Two things here. So what happens if is that the only party, in the real world, guys? You don't only sue Studio X, who else will you sue? You would want to hold both Tanya and Studio X, liable, jointly and severally liable. In other words, the one is to be liable. We're going to prove, because if you prove liability on either one, they will have to pay. So you can have what we call joint liability, that they're both liable, or several liability. Either one of them is going to be liable. And then ultimately, let's say that Cindy takes them to court. The first defendant is Studio X, Pty Limited, and the second defendant is Tanya. Okay, then Cindy now proves that all these elements and all the proves the vicarious liability and court orders joint and several liability, the one paying the other to be absolved. And Cindy's lawyers think that, okay, well, Studio X liable, and Studio X pays Cindy's damages. Is that the end of it now? So Cindy is to be, or the company is now going to pay, and Cindy is off the hook. What does this joint and several liability mean? It means that the party can hold either one of them liable or hold them together liable. So if the damages that they were awarded, came to 100,000, they can claim 50,000 from the one or 50,000 from the other, or they can claim perhaps 100,000 from the one only. It doesn't really matter as long as they get the money. But what I'm trying to get at, guys, is that if the company, if Studio X was then, the party against whom Cindy's lawyers were going to hold liable, then Tanya at the end of the day would still be responsible for her part of the damages. Right? And this means that the employer may then see this as monies owing to them, because they may have paid the debt that was due by Cindy now. Okay? And the employer can take steps to recover those monies from the employee. That is what I'm getting at. Any further questions on that?
No.
You guys cool with that? Because it's not a nice situation, guys, to be held, personally liable. So what did you tell Cindy now? What should Cindy do? That she should go for both of them? I would say that yes, you should sue both Tanya and Studio X, and it doesn't really matter who ends up paying. But in practical terms, you'd want to hold the company liable. The company would be more, there's a greater chance of the company being in a position to pay rather than the employee. Okay. So now we move on. Give 3 practical examples of when one would be allowed to employ someone on a fixed term contract for longer than 3 months. Okay, this is an interesting question. Note, okay. I'll leave that. That's not important. The main question here is to give me 3 practical examples of when someone would be allowed to employ someone on a fixed term contract for longer than 3 months. Now, why is this such a question, guy? What is a fixed term contract or a fixed term employee? Give me an example of a fixed term contract or fixed term employee.
Okay, I have one
Yes.
from real life. A friend of mine works for the governing body of a school and is employed on a year-by-year contract. So it's never permanent. It's renewed every year. Yeah.
Okay. But now we must, thank you, Julie, but we must bear in mind that that employer there is already in difficulty, as you said those words, okay? Because the LRA says that, you know, fixed term contracts are basically when you employ people for a certain period or for a certain event or for a specific project or a specific task. And the understanding is, you know, or when they reach retirement. So the understanding is that once you reach the milestone, then the contract will end. All right, I employ you as my secretary to work on this big construction project for building a stadium. It's going to take 3 years. And then when we do the job after 3 years, I'm going to say to you, well, look, I don't have a job for you anymore because we've come to the end now. That is an example of a typical fixed-term contract. But what does the LRA say about fixed-term contracts longer than 3 months? It says that the minute you go over the 3 months, yes, Queen?
I was going to say, if the job is not done within that 3 months, then the contract can be extended to longer than that.
Correct. So that's the whole idea. This is what the LRA is trying to fix now. It's saying the minute you employ somebody for more than 3 months, you can employ a person for up to 3 months on a fixed term contract. And when the 3-month contract expires, that's it. Thank you. Goodbye. But the minute it goes longer than that 3 months and the person, one of those factors are present, which is included in the dominant impression test, which is all those factors, like you go to work there, you are part of the organization, they deduct this from you, they control how you must work, when you must work, your work hours, your leave hours. Then it appears very much, if any other one factor is present in the law, says no, you're no longer a fixed term employment contractor or worker, you are an employee now. And the onus moves on to the, excuse me, the onus moves on to the employer now to prove to the bargaining council or the CCMA that, yes, you know, the person is indeed either, you know, they must justify why the person is not an employee. Not the employee must justify it, the employer must justify it. So hence the question is asking us, practical examples when one could allow to extend that term. So what do you think those would be? You know, typically, what about maternity leave? You know, you employ somebody, a lady has gone on maternity leave. What's the minimum? What is how long is maternity leave in terms of law?
4 months.
4 months, right? So automatically, if you're going to take the 4 months, which you're entitled to by law, it is longer than the 3 months. But now when you come back, obviously you would be entitled to your job back now, right? You must continue working. And the person who replaced you for that period will also, their contract will come to an end. So there's a number of things that will, you know, a few things that the employer will be obliged to prove why the contract is longer than 3 months. So why is this such a big deal, guys? Because once a contract is longer than 3 months and the employer can't justify why it is longer than 3 months, because this is what the law is saying. The law is making it hard for employers to employ people for 3 months without a reason. The minute you can't justify it, you're considered a full-time employee, and if you want to then cancel the contract, you are also, as an employee, entitled to certain kinds of benefits. You're entitled to like a retrenchment pay, you know. So you must be very careful. You must be able to have a justifiable reason, and the justifiable reason is for you as an employer is it's even mentioned in the book there. You guys can have a look at it. So replacing another employee who's temporarily absent from work. You had to increase that for more than 3 months because of temporary increase in the volume of work. That can happen, okay, which is not expected to last beyond 12 months. So, I mean, you get people that have seasonal work, you know, factories, they get big orders. Now they say, well, we need people to work. And in that case, if you're now being employed as a graduate to get experience or a project, like I mentioned to you, okay, so all these things can justify why the contract is longer than 3 months, so that you don't get punished as the employer for employing a fixed-term worker for longer than 3 months. Just excuse me a sec, guys. I've got my dogs going crazy. Just 1 second. Give me a minute. Sorry about that, guys. Dogs went nuts there. Well, what happened to, what's her name? Okay. You all there?
Yes.
Yeah, okay. All right. Okay, so we continue now that you can't. So in reality, if we look at all these sections of the labor laws, that you can't as an employer actually employ someone for longer than 3 months. The minute you go over 3 months, there's this presumption that it's against you, okay, as an employer, and then you have the difficulty of having to prove that the person is only a fixed term contract and that it was justifiably extended, okay, for the reasons that I mentioned. Otherwise, you have to now pay them out, you have to pay them, go through a procedure, the right to not to be unfairly dismissed, you have to pay them severance pay, and it becomes a costly exercise. All clear on that?
Yes.
Okay. Now, 2.3, compare the ways in which an employer, or an employee rather, I beg your pardon, is different from an independent contractor. 6 marks for jam, guys. 6 is marks, simple marks. Compare the ways in which an employee is different from an independent contractor. So you have to give 3 of one and 3 of the other, but it can't be isolated. In other words, that it must be disjunct now, you know, like you can't compare the one. So we know, for example, an employee renders personal services, as an example, in terms of his employment contract. Now, the counter to that is the independent contractor. How would you say? How would you compare to that? The independent contractor, as you said earlier, Aisha, delivers specific and specified work or services, you know, or projects, right, related to an outcome. Paint my house. Okay, you paint the house. Thank you. That's it. You've done your job. I'm happy. Goodbye. Okay. But with the employee, he's not rendering his services, his personal services and time to the employer. He's putting himself at the employer's service. Okay, what other differences are there? The differences between an employee and an independent contractor. Just think practically, you'll be able to get all these answers. right? I mean, the way the work is done. An employee is told when to work and how to work, right? An independent contractor, may be told perhaps when to work and how to work, but to a far less extent, right? You cannot interfere once you've taken an independent contractor as to certain methods unless you come to an agreement on that. But the independent contractor has far more leeway and far more freedom than the employee in that regard. Okay. The third comparison one could make is the fact that the employee, is the one that must render those services, but the contractor, he must ensure that the specific project is completed. So it doesn't always have to be the contractor personally to do the work. It can be somebody else. In some cases, even may be agreed to subcontract. Okay, you hire a builder to build a house. It doesn't mean the builder himself will lay the bricks. The builder himself will put in the plumbing, and the builder himself will put in the electrical works. He will get various people to do those things. Okay, any further questions on that? Yes.
Can we add the fact that the independent contractor has a contract when it expires or when the work is completed and the employee is obviously permanent? Can that also be an example?
Yeah, but you must explain it a bit, man. Because now look, if you do enter into a contract with an independent contractor, and the contractor is a company, right?
Yes.
And now, let's say the person that represented the company moves away. He doesn't work there anymore, and somebody else is now taken over. At the end of the day, the company that you contracted with will still be liable, right? So those obligations will still continue, despite who's representing the company. But an employee it's of a personal nature. It's a person that has to actually render services.
Okay.
Yeah.
Yes.
Okay, you guys go back here. Using your own words as far as possible, explain the concept of a delict. I'm not going to do that again, okay? We did that, right? Unless you want me to...
Now we're comfortable. I'm comfortable.
We did that, yeah. You cool with that, Queen, or what?
Yes, no, I'm cool with that.
Okay. We move on. What remedies are available should a party in breach of... what remedies are available should a party be in breach of a contract of employment? What can you do? Now, okay, you guys haven't done a study on the law of contract, eh?
No.
No, okay. But typical remedies for breach of a contract is, when somebody commits a breach, you can accept that breach. In other words, something, you can terminate or cancel the contract. You can ask for specific performance. Okay. You can also ask for damages. So when we speak of a breach of a contract, let's think about it very practically. How many parties in a contract of employment? How many sides? How many parties to that contract?
Employer and employee too.
Right. Now, there's an agreement, there's obligations on both sides. Okay, so either one can do something that can break that agreement. How can the employer break the agreement?
Retrenchment, dismissal.
Dismissal, which yes, right, good points. Failure to pay, that is also now a breach, right?
Yes.
And the employee can also breach it through, various acts of misconduct, or being incapacitated, or simply resigning also. So there's various breaches. Breach means to breach a contract means to interfere with the obligations, of the contract. So the next question is, who may make use of the remedies mentioned in 3.1 above?
I think both of them.
Yes. Right. Both of you are right. The party who basically is the victim, the innocent party, right, who didn't commit the breach. So the employer, it comes to the end of the month, the employer hasn't paid you. Now, whose fault is that now? Right, it's the employer's fault. So he's breached it. So you have remedies now. You can either accept it and say, okay, look, you haven't paid me. Pay me tomorrow, or I'm going to do something, right? Or you can say, you know what, I'm going to leave. You could resign. Or you can, there's various things that you can do, okay? So it depends. Same with the employee. If that employee doesn't come to work, the employer is more basically limited in the options that they can do with employees, right? They can't just simply exercise dismissal, which is termination. They have to invoke certain things and follow certain procedures. Otherwise, it won't be considered a valid dismissal or valid cancellation of the contract. All right. Next question. In the case of Magna Alloys and Research South Africa, the appellate division, as it was then known, it's the AD, is what's it called now? Yeah, they even put it as A or AD sometimes. What is it called now? Do we still call it the appellate division? What do we call it now? Supreme Court of Appeal, isn't it? That is now the Supreme Court of Appeal. It used to be called that before, the appellate division. All right.
Oh, I didn't know that. Okay.
That is why these are old cases. This is 1984, before the Constitution. Right? Now we don't speak of it as the appellate division. We speak of it now as the SCA, the Supreme Court of Appeal. So, but nonetheless, this is part of our common law, our contractual common law was developed, and perhaps this is what you need to look at. In the case of Magna Alloys, the appellate division held that the court must ask certain questions in order to determine whether the restraint of trade clause is reasonable and therefore valid and enforceable. Now, let us quickly, did we cover this in our earlier lessons, guys? The restraint of trade? Aisha, can you perhaps recall?
I'm just going through my notes, but I think we did.
Did we?
But
in any case, what is the restraint of trade, number one? And number two, is it lawful? Is it enforceable at all?
I think as long as it's reasonable, it can be enforceable.
Yes, can be enforced. That's about exactly right. Yes, that's the short and long of it. If it is reasonable, it can then be enforced. So what we are actually saying it is allowed. It is lawful. It's not that, oh no, you can't do such a thing. Employees can't have such terms in their contracts to restrain you from competing with them or trading with them. it is allowed, and this was the case, that the appellate division decided under our law that, yes, it's not unlawful or wrongful or against the common law of contract to have a term where you restrain your own workers from competing with you. But as long, so it is in terms of public policy. So public policy means that, there should be a law in place to regulate a certain issue. So they felt that they should be allowed to regulate situations of employees who compete with the employers unfairly. Okay, so to be considered reasonable, there were certain questions. So in order, you can have a restraint of trade, but all it must be is it must be reasonable. And if once it is considered reasonable, you can take a person to court on that. Now, what are the questions the court asks when considering whether a particular restraint of trade clause is reasonable? Right? This was the famous case. It was also repeated in Basson versus Chalwan, another case, So this is common. I mean, you must ask, is this something that the employer needs to have protected? In other words, a protectable interest. Okay, and the employee will have to show that he has a protectable interest. Now, what is this protectable interest? Like, for example, if you come and work for me and I make a particular formula, how to make a particular food product, okay? And everybody comes, my business is based on this formula of how I make this particular product. And now, because you work with me, you learn all my secrets. You learn my clients, you learn my suppliers. In fact, you are thinking, gee whiz, man, I'm working here. I know everything. I can actually just leave here tomorrow and duplicate the whole thing. And therefore, I'll have an edge. Okay. So that is that protectable interest that the employer must basically show that he needs protection from. Something that, is worth something of value that an employer has and needs protection from an employer to get an unfair advantage. So those are the questions. Is there an interest deserving of protection? Okay. And you must prove a protectable interest. And is that interest being prejudiced? Right? That is what if the employer were to go away and start to compete with me, then will all my business secrets and all the things that I've worked hard for be prejudiced? Right? That's the second question. And if it is being prejudiced, then how does it weigh up against the interest of the employee? Because the employee also has the right to a right of profession, a right to trade, a right to pursue his own commercial interest, right? So you can't stop him from working completely on the other hand. Okay, so the court must look that up now. That okay, consider that, weigh that up. If is this clause not too restrictive? So everything will depend on the type of clause and the words in the clause of the restraint of trade. The fourth question is there another facet of public policy from the relationship between the parties which requires that the restraint should either be enforced or disallowed? Okay, so the court will look at overall fairness. So generally, the courts have answered this question affirmatively by saying that wherever there is this unfairness, like I've described to you now, then it is worthwhile to protect an employer from an employee who's trying to get an unfair advantage. Okay, and they weigh up the reasonableness of it. So I did a restraint just now before the lockdown. We restrained a guy from competing with his employer, and this guy was working for his employer in a very niche field. Okay, where he's got this very specific way of hanging art in galleries and in high-end, individuals' places of residence. So he's got this particular method, and this is what the business was about. And this guy he employed for a few years. He trained him up, And in the last couple of months, he found out that this guy is actually starting to approach his own clients to do work with him without the boss knowing. Okay, and there was a written restraint of trade agreement in place. And eventually the court said, yeah, okay, we can restrain him. The restraint of trade clause said that this guy can't, we should leave him, he can't compete with him for a period of 5 years in the same industry and in an area 100 kilometers outside central area of Cape Town, with a radius of 100 kilometers from the center of Cape Town. So do you think that that is reasonable, that kind of enforcement? 5 years and 100 kilometer radius?
Five years is a lot, though.
Yeah, and that is why I told my client that, look, you know, we're not going to make it on 5 years because that would sound too oppressive now. Right, and the court would look at this reasonableness and think, no, but now this man can't do this kind of work for 5 years. That's a very long time. You know, maybe a year would be, you know, something to ask for. So in the end, the guy was interdicted for a year, you know, within 100 kilometers of Cape Town, CBD. Okay. So the main thing to remember here is that restraint of trade clauses are lawful, they are permitted, only to the extent that they are reasonable, and if they are reasonable, they can be enforced. And we have time for one last question. Okay, advise an employer whether or not they need to obtain agreement from the employees to cancel an annual Christmas party. What do you guys think there?
No, they don't need a agreement.
Because this has got nothing to do with the job description and the terms of your contract, unless, of course, it did say that. But I mean, employment contracts don't have terms, you know, generally that deal with outside curricular things. So an employer is quite entitled to say, nope, we won't have a Christmas party. Okay, and they can't be forced to keep one. Unless, of course, it was a term of the contract itself. Okay. When are you guys? How's everybody doing? It's our time, guys. But how is it with your prep? You must send. Here's the link also. Previous sessions and book a one-on-one session with your facilitator. Click on there if you want one, and I can take it from there, or you can email me, you know, and I will set up a session if you want one.
Where is your email address?
Okay, let me give it to you as well. Here is it. You don't always come right to the links that they give you, I think.
Where can you get the previous recordings?
There's a link in the chat which you can click on. It will take you to those links. You see it there, Queen?
No,
in the chat box
yet.
there.
So
Yeah, just look above there.
you must click on
okay.
the conversation.
Yeah, and if you go higher up, there's
direct.
another link. Yeah, but you can send me an email request, and then I can set up a session, a one-on-one.
Cool.
Okay.
Okay. Because this is my
Okay.
last session. I won't be
Is
the
it-
next two. Yes, because I'm
Okay.
writing on those
You're
two
writing, huh?
days. Yeah.
I see,
So I might
see.
just contact you if I
Oh,
stuck
no
with anything.
problem. No problem. No problem. You do that.
Thank you so much.
See, I am contracted to do that, so you are welcome. It benefits
Okay.
both yourself and me. So I welcome that. You know, it's not like it's a special favor or anything. It's part of the service, and students are really, I don't know why they're not making use of it. You know.
I don't know either. That's
Cool, man.
crazy.
Thanks.
Okay.
I'll chat to you again. Okay, Queen.
Okay.
Okay, Aisha.
Bye.
Okay. Bye.
All right. Thank you. Bye.